I am most grateful, my Lord. My Lord, I am the defendant, applicant, appearing for myself in person, and I most respectfully adopt as my argument in support of this very motion on notice the following processes which I personally filed and served on the prosecution. An order, this motion, my Lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Emmanuel Kanu, together with all annexures. My Lord, my written address filed in support of the motion, wherein I adopted and argued the three jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally, because count 7, my Lord, does not exist in the laws of this very country. When I reply on points of law, I will make specific references to the ratio that came down from the Supreme Court, where my Lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order. My Lord, the entire argument of the respondent, I'm sorry to say, collapses on just one single point, not many, just one. The Supreme Court's pronouncement on the status of the written law is immovable. It is enshrined in the Constitution of this very country unless a law is written. Unless it is written, defining that very offense, no trial, no conviction can ever take place. And it is my submission, my Lord, that this very morning, as we stand in this very hallowed chamber, count 7 does not exist. I'm not going to repeat laws, that will come later. Count 7, my Lord, destroys this entire trial because Supreme Court gave an explicit order which wasn't adhered to.
The consultant, you have to go to the defendant to tell him the procedure here. We have the practice of front-loading. I think he has filed his written addresses in support of all this motion. So it's not to repeat what he has stated in his written addresses, but to state the relief is sit for, and just use a minute each in respect of each motion for adoption.
Okay. They didn't reply to it. Yes. I am most grateful, my Lord. I am, without flogging a dead horse, I am asking this very honorable court, my Lord, to please kindly grant my prayers as contained in the motion for reference to the appeal court, and may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my Lord, deposed to by my younger brother, Prince Emmanuel Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed to by my humble self, also filed on the 12th day of November 2025, and also a written address. My Lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November. My Lord, may I most graciously ask my Lord to grant these prayers. Thank you very much.
What about the other 2 motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the 3 motions.
Okay. The next one, my Lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You have the grounds stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third and the very last one is the issue of bail. My Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It's a very simple one. It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Emmanuel Kanu, and also by a written address which I urge, my Lord, to accept its adoption. Honorable Lord.
Yes. You moved the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The prosecuting counsel, can you react to those 3 applications?
May it please your Lordship. The prosecution filed reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your Lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your Lordship to determine that in other ones. But the one asking for stay of proceedings, my Lord, our argument is to the fact that the statute does not permit your Lordship to grant any stay of proceedings or injunction. So we ask your Lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your Lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for Lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your Lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter bill, the latter application with respect, is an abuse. In any event, none of them merits. We urge your Lordship to dismiss it.
Please, let's save the time of the court.
We appeal your Lordship to dismiss all the applications because they lack merit and do not deserve any consideration at all. Thank you, my Lord.
Thank you, sir. Defendants, you have one or two words to say?
Certainly, my Lord, and I'm most grateful. My point is a very simple one, my Lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my Lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my Lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My Lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Okpara is okay. Where are the others? Ejiofor, where are the others? Yes, you just have 2 minutes for this. Yes. Yes, up 2 minutes for this.
Thank you, my Lord. I'm most grateful. Once again, I will start with the bail application that I made. Since he did not file any counter affidavit, my Lord, he is in effect conceding. And I expect that this very application should be determined based on the affidavit that I filed.
You may sit down.
And on the issue of stay, my Lord, once a matter borders on jurisdiction, stay can be granted. Once it is a jurisdictional matter, stay can be granted. What I'm asking for is for a referral, my Lord, to the appeal court for the determination of these very key issues. And also, I reiterate that AJA is not superior. It is not superior to the Constitution of this very country. And an established jurisprudence as determined by the Supreme Court, that stays can be invoked insofar as the issue borders on jurisdiction. And my Lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C-45, my Lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my Lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Can you
Just,
summarize?
yes, please. I ask my Lord that I be granted bail on very favorable terms, given that a concurrent judgment of the Supreme Court of Nigeria determined, my Lord, and found that I did not jump bail. I never did. That was their finding. I did not jump bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my Lord.
Thank you.
I've said it.
You may sit down. I'm going to read extempore as the application and all before these courts. The defendant filed 3 applications after the matter was adjourned to today for judgments. The defendant filed a motion on the 17th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicant in the absence of a valid subsisting charge under a written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The second relief is an order staying further proceedings in the charge, pending the determination of the referred questions by these courts to Court of Appeal. The third motion has to do with the notification to file written